Okay, well, let's go ahead and get started. How many of you have actually had training on the GALRs before or passing familiarity? Okay. So I'll ask you, those of you who have, what are you hoping to get out of this training?
Well, believe it or not, I do still tend to forget things.
Thank you, Todd. Others?
It's been 6 months for me, and I would like to be able to recall them off the top of my head rather than going back to the 3-ring binder.
Thank you.
I'm new, so it's all fresh. So it's good to hear it a second time so it sinks in better.
Nice. Okay. Well, let's go ahead and go into this. The rules, a review of GALR2 for guardians ad litem and child advocates. It's already 2022. Rules are continuously updated. This document is not intended to encapsulate all rules forever. Please go to the original source for updates. So it's been a long time since these rules were updated. And they still haven't been updated. In fact, when we were going through a bunch of organizational changes, when we were changing our name, that was one of the things that I asked the judges. I was like, do we need to look at these? And they all just were like, are you kidding? No, they're fine. We do not want to open up that can of worms. So these have not changed probably in 20 years. We need rules to provide guidelines and common practice for all the parties. They give us structure. They provide boundaries for system practitioners, and they give us guidelines for how and when to address problems. I really like this training in particular because it does kind of put out there some of those ethical issues that you might face as a GAL as you're doing this work. And so just trying to figure out, understanding these rules and understanding the intent behind them, hopefully will help you guide in the ethical practice of your work. There are many places that you will find these rules. So these are all on the court's website at courts.wa.gov. We'll also be talking a little bit about some of the RCWs that govern our work as well. And then local county rules. There are local county rules that govern GAL work, but for the most part, those local GAL rules are covering things like when to file a motion, how to file a motion. They're very technical about, we do calendars on this day, we do calendars on that day. So if you have them, they're usually very, very specific to your local county in terms of kind of what they're discussing. The other thing that is included in each of your GAL and each of your local court rules, and they are required to have this as part of the statute, grievance procedures for guardians ad litem. So when somebody doesn't like the work that you're doing or the work that you've done, grievance procedures are also included in that. And most of the time those mean, here's the formal process that you would use if you have a complaint against a guardian ad litem. Sometimes it's the program that does the investigation. Sometimes it's a juvenile court administrator. Other times it's the court, but those are all dictated locally. Those grievance procedures are all local designs. And we won't be covering those because there's 39 counties in Washington, and we just don't cover all of them. So this comes from the prologue of the GALRs. The purpose of these rules is to establish a minimum set of standards applicable to all Superior Court cases where the court appoints a guardian ad litem or any person to represent the best interests of a child, an alleged incapacitated person, or an adjudicated incapacitated person pursuant to titles 11, 13, or 26. Does anyone remember what title dependency falls under? Anyone?
13.
We are 13. That's right. All the dependency stuff is Title 13. What about 26? Have any of you guys heard of Title 26 GALs and what they do? Anyone?
Are they the ones who work with family law?
They are family law guardians ad litem. So they do the same thing, except they're working in divorce and custody cases. Their mission is to speak for the best interest of the child and usually try to figure out who gets the kids and for how long. And then finally, Title 11 are for adult incapacitated. So if you've got somebody that can't, for whatever reason, be their own advocate or self-advocate, the court will appoint a best interest guardian ad litem to those folks as well. The trainings are completely different between all three of these. So you could not be an adult GAL because you've taken the Title 13 training. Likewise, you can't be a family law guardian ad litem unless you take the Title 26 GAL training. They're not the same. Even though for these rules, they are combining all three of those different types in terms of what it means to be a guardian ad litem for either a kid or an adult. So sometimes you'll see this towards the end when they're talking about getting paid and compensation and how you go about asking for that. That doesn't apply to you because you guys are suckers and you do it for free. Joking, but all right, so why do we have these minimum standards? Because we're working with kids and incapacitated people, and they have limitations, and these are vulnerable populations. So we need you to be aware of these rules so that you don't violate them and are doing your work ethically. All right, so we're going to be going over GALR 2. The other ones are there's nothing in them that really pertain to us. So this is where the meat and potatoes are. So just like we've done before, so that you all don't fall asleep during this presentation, and I don't fall asleep during this presentation, I'm going to ask for volunteers to read each of these GALRs. So may I have a volunteer to read what's in the light blue, bluish gray box? Please.
I'll do it.
Okay.
Okay. A guardian ad litem shall represent the best interest of the persons for whom he or she is appointed. Representation of best interest may be inconsistent with the wishes of the person whose interest the guardian ad litem represents. The guardian ad litem shall not advocate on behalf of or advise any party so as to create in the mind of a reasonable person the appearance of representing that party as an attorney.
So best interest versus advocating for a person's wishes. You all are best interest advocates. That may or may not be consistent with what the kid wants. Right? You still have to report to the court what the kid wants, but you do not have to be an advocate for what the kid wants. If the kid has very strong desires or wishes or things that they want to see happen that are inconsistent with what you feel is in their best interests, then one of the considerations that you'll want to talk to your program about is maybe whether or not this child should have his or her own attorney representing their stated interests. The other thing that's included in this law or in this rule is this idea of not making it very clear to everyone that you're not an attorney. Right? So how might you let somebody know that you're not an attorney? Anyone?
Tell them you're not.
That's it. It's super easy, right? You just say, or when they ask, you say, no, I'm not an attorney. Or when you're introducing yourself, hi, my name's so-and-so. I'm the child's guardian ad litem. I am not an attorney, but I am here to represent this child's best interests in and out of court. Don't need to make it more complicated than it is. Whoops. All right, Bonnie, you get to read B.
Okay. B, maintain independence. A guardian ad litem shall maintain independence, objectivity, and the appearance of fairness in dealings with parties and professionals, both in and out of the courtroom.
So I'm going to answer these questions for you. The court relies on your independent assessment of the case. Because if you think about it, the social worker is trying to prove what they want to see happen to the case and why they're there and justify their work. The parents, obviously, they want to see the kids go back home, or they want to see what happened. You know, they have their agenda. They have their side of the story. You guys are the neutral party. We need you to be independent. The court needs you to be independent. You are independent gatherers of fact. You need to have that appearance of fairness and a peer objective, because sometimes people will accuse you of not, or having folks will, especially other parties may say, well, you want this to happen, or you want that to happen. That you cannot let that be the case. You have to take in the information and then make your recommendations. You don't get to make recommendations and then find out why reasons to support those. That's not how this works. And don't get caught in the trap. Others in the system have the ability to pick a position and stick to it. You as the GAL do not. Your role is unique and special. As you gain new information, your recommendations can change. That is way different than the attorneys in these cases. As you discover new things, you are allowed to say, at first I thought we were going this way, but now I've gotten this new information, and so now we're going to go this direction instead. That's okay. So what we need you to do to maintain that independence is interview a large swath of individuals. Talk to as many people as possible, anybody that has connections with that kid, including parents. Researching relatives, right? Finding relatives as potential placements or supports to the child. Those are all pieces of your gathering of information. This also includes not sharing details of the case with anyone other than the court. We'll talk about that later when we talk about confidentiality. This includes not being buddies with anyone, or even having the appearance of being buddies with anyone. We hear often from parents who have been through this system that they felt like everyone was against them, including you, right? Because the GALs, they were always talking to the foster parents. They never would talk to the parents. And that makes it difficult to have a professional working relationship with those parents. You need to be able to do that, not pick a side. And again, you might be tempted to dig your heels in on an issue, but you got to remain open to altering your recommendation based on new information. That's how you practice independence. Questions so far? Give equal time to parties. If you spend 45 minutes at mom's visit, spend 45 with dad. If you contact caregivers to see how the child is doing, call the parents and see how they think the kid is doing. Get that full perspective. If you say hello to one party at a meeting or in court, make sure you say it to all the others there as well, and in the same way. Like, don't run up and be like, oh, blah, 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 foster parent. It's so great to see you, blah, blah, blah. And then be like, sup, mom, when mom walks in. And then sit next to your fellow VGALs or your other folks, sit next to your people in court. Sitting next to a party in a case may give the appearance of bias, and we're trying to avoid that as well. Annette asked, does equal time include children time? No. You can spend as much time with the kid as you need, but you also want to be careful that you're not spending too much time. There's a balance there. Other questions? C, may I have a volunteer, please, for C? Go ahead, Annette.
Okay. Sorry, I had to unmute myself. A guardian ad litem shall maintain the ethical principles of the rules of the conduct set forth in these rules and is subject to discipline under local rules established pursuant to Rule 7 for violation.
Yes.
Wow.
Even though you are a volunteer, you can be subject to discipline. Even though you're a volunteer, yes, even though you are a volunteer, there must be oversight given the vulnerable population served. And in order to trust in your recommendation, the court needs to know you are following the rules in a professional manner. So remember how I said earlier, the only thing the local court rules contain of use to you all are the grievance procedures. That's what we're talking about. So when you mess up, what's the process for either getting you off the case or addressing those grievances? And just as a hint, for those of you that may not be aware of this, guess why we're going through all of these guardian ad litem rules?
Because they're very hard to read for a layman.
Or they're also very, yes, there is that aspect of it. And they've all been violated at some point or another. So we want to make sure that you are aware of what those rules are. So, and that all this is saying is like, yes, you can get in trouble if you don't follow these rules. Even though you're a volunteer. Oh, look. Here's the GALR 7 that they were talking about. Each court shall promulgate rules that set out or refer to policies and procedures, establishing and governing the filing, investigating, and adjudicating grievances made by or against guardians ad litem under Titles 11, 13, and 26. D, may I have a volunteer for D, please?
I'll do that.
Thanks, Cheryl.
Unless accepted by statute or court rule, guardian ad litem shall satisfy all training requirements and continuing education requirements developed for Titles 13 and 26 RCW guardians ad litems by the administrator of the courts, and maintain qualifications to serve as a guardian ad litem in every county where the guardian ad litem is listed on the registry for that county in which the guardian ad litem serves, and shall promptly advise each court such court of any grounds for disqualification or unavailability to serve.
Thank you. So, summarizing this one, you need to stay current on your training. That's how you remain qualified for the registry. So all the programs across the state have a minimum requirement that you have to do 12 hours of continuing education each year. That is how you maintain qualifications for the registry. That's how you stay active. Right? The other ways that you may be not qualified for the registry, I know a lot of the programs will say if you haven't had a case in a year, you need to retake the training, right? You're no longer qualified, you need to do this again. Or if you take a 5-year hiatus, you're going to have to redo the core training. Things change. a lot in child welfare. Especially these days, we've got a very active Supreme Court in Washington that is actually taking on more of these cases every, each one of their terms. The legislature's been becoming really involved. So there's a lot of changes that go on from year to year. E, conflicts of interests. Volunteer, please.
I can do this one.
Cindy, go ahead.
A guardian ad litem shall avoid any actual or apparent conflict of interest or impropriety in the performance of guardian ad litem responsibilities. A guardian ad litem shall avoid self-dealing or association from which a guardian ad litem might directly or indirectly benefit, other than for compensation as guardian ad litem. A guardian ad litem shall take action immediately to resolve any potential conflict or impropriety. A guardian ad litem shall advise the court and the parties of action taken, resign from the matter, or seek court direction as may be necessary to resolve the conflict or impropriety. A guardian ad litem shall not accept or maintain appointment if the performance of the duties of a guardian ad litem may be materially limited by the guardian ad litem's responsibilities to another client or a third person, or by the guardian ad litem's own interests.
Whew, thank you. So this talks about conflict of interest and impropriety. If you come across a situation where you feel like, this might be a conflict of interest for me, we need you to tell your coordinator. If you somehow break a rule or do something wrong, we need you to tell your coordinator. Don't try to hide it. I guarantee you, the programs, it's so much easier for us to respond to something when you tell us rather than when we find out about it later. Because the last thing that we would want to see happen to you is that you're on the stand and you get cross-examined about something that you didn't tell us and that we couldn't prepare for. That's not fun for anyone, except maybe the person who's cross-examining you. So don't put yourself in that position. Talk to your coordinator so that we can address the situation. And so what that typically will look like, sometimes they'll be like, no big deal. Don't worry about it. No big deal. Other times, and more frequently, the issue will be, we've got to let everyone know on the case, right? So we're going to email all the parties about what happened and tell them what we did to fix it. Right? So they'll email everyone and say, so-and-so let out this piece of, our volunteer let out this piece of information that she shouldn't have. We told her that that's wrong. We corrected it. Is that sufficient? And sometimes the attorneys will be like, sure, that's cool. I understand. Other times we'll get attorneys to be like, no, that's not enough. Like, you've seriously put this case in jeopardy. And so if that's the situation, we'll talk to them and kind of see what their resolution may be. They may ask that you be dismissed from the case. And if it's really bad, they may say, we are going to file a grievance. And if you are the subject of a grievance, right, where you actually go and follow that whole procedure, that will remove you from any GAL registry forever and ever. You will not be permitted to do this work ever again. I've been doing this for a while, for about 20 years, and I've never heard a situation where a grievance actually went through all the way. Usually what happens is the volunteer will resign. So some examples of conflicts of interest or improprieties. Working at the same treatment center a parent goes for treatment. Right? So if you're employed by a treatment facility and you've got a parent that's coming in there, that might be a conflict of interest. It doesn't mean that that's an automatic disqualification. It just means we need to know. so that we can account for that. Owning an apartment or a trailer where a foster family lives. Again, not a deal breaker, but we need to know. You need to disclose that information to us. Having a personal relationship with the parents or foster parents or relatives on the case. Basically, if you've got a previous relationship with those folks, you need to let us know. For example, oh my gosh, I go to church with the foster parents. We sit next to each other every Sunday. Or I dated the parents, or I went to prom with one of the parents, with the parents' brother, right? Like stuff like that. That doesn't mean you've done anything wrong. It just means we need to know so that we're not surprised and we can address that ahead of time and have that conversation with other parties if need be. Taking a parent out for a drink? No. Entering into a romantic relationship with anyone involved in the case? No. Selling something to anyone involved in the case or paying anyone in the case for personal services? Don't hire your kid to mow your lawn. Don't hire your parents to mow your lawn. Don't sell them a car. Don't give them a car. Nothing like that. Speaking poorly about the parents to anyone, or sharing confidential information with foster parents, relatives, or others. Remember, the only people you can share information with are parties. You can get information from anyone, but you can't give information unless they're a party. Oops. Questions about conflicts of interest or improprieties? Okay. F, may I have a volunteer, please? Brett?
I can read that, Ryan.
Thank you.
Yep. Treat parties with respect. A guardian ad litem is an officer of the court and as such shall at all times treat the parties with respect, courtesy, fairness, and good faith.
Dependencies can become emotional. Check your emotions at the door and follow the golden rule. And the golden rule is, for those of you who may not be familiar with that, is do unto others as you'd have done unto you, or something like that. But do not speak or write negatively or poorly regarding anyone in the case. Keep your frustrations, irritations, dislikes, and feelings out of it. I can't say this enough. You've got to remember, especially when we're dealing with parents, most of the time we're interacting with them at the worst part of their life. Don't judge them by that one page that you're reading. Tom? Oh,
Sorry.
it's okay. Betty, did you have a question?
No, I'll read the next one.
Thank you. You're on deck. Stay focused on the facts, your behavior-based observations, and your assessment of those. The last thing that we'd want to see is you somehow being, that stuff when it comes out, it's devastating to your relationship in working with parents. You need to have that relationship. And if you're making fun of a social worker or attorneys too, like that, that's a hard thing to overcome. Just don't do it. I know we used to say, oh, you should go and complain to your supervisor. I would encourage you to like not even let your brain go there. It's so easy to start that. Don't do it. Annette?
Oh, sorry.
You're fine.
Oh, you heard me. Okay. I'm back onto the conflict of interest.
Sure.
Because I went to visit both at the children's school And they had a placement from 2 days, like 2 placements ago as an emergency contact. Nobody had ever let them know where the kids were actually staying. I gave them the information that they were staying at their aunt's. I didn't say that they were placed there. I said at the moment they're with their aunt. Was that a conflict of interest?
It wasn't a conflict of interest, but it was an impropriety.
Okay.
You're okay. This is, so Morgan's not here to correct all of us either, right? So, but like, you got to be careful. So that information was, you could have maybe handled that differently and said, hey, social worker, I need you to follow up with the school. And I know that that's not always going to happen. You could have also followed up with the aunt or the placement themselves and say, hey,
I did.
Perfect.
I told her afterwards, I said, they still have this placement, and because the social worker was out of town that week.
But Annette, I would still tell my folks,
Okay.
you know what I'm saying? Like, hey, I was there, just like you told me, I was there. Nobody had the information. I gave it to them. And then that way, so the program gets to have that ability to say, I guess we should email all the parties and just let them know that that was disclosed. Or the program may say, don't worry about it, but let's think about how we might handle that differently the next time.
Okay.
You're good.
Got it. All right. Thank you.
No problem.
I've been worried about it ever since that screen.
Again, that's where you call up your program and say, I just did this. I know I probably shouldn't have, but it just made too much sense for me to say it. And let them slap you on the wrist.
Okay. Thanks.
Yep. All right, Betty, let's read G.
Okay. Be informed. A guardian ad litem shall make reasonable efforts to become informed about the facts of the case and to contact all parties. A guardian ad litem shall examine material information and sources of information, taking into account the positions of the parties.
You must do an independent investigation. We need you to verify stuff for us. The court does. We do not need you to read through all the documents and give your assessment of what's going on in the case. Do you know why we don't need you to do that? Because it's already somebody else's job. Whose job is it to read through all the materials in the case and make recommendations about what should be happening? Anyone? Guys, all have your cameras off. I'll answer that. It's the judge. That's their job. They don't want you doing your job, their job. They need you to make sure that all that stuff that they're reading is true. They need that independent analysis by you. This is an extreme example, but I'm going to tell it anyway. During the pandemic, we had a social worker that said that she was traveling to Idaho every other week to see this kid, submitting mileage claims, doing all of this work, talking about the kid and the placement. Turns out after some of the restrictions had been lifted, the GAL went out there to go talk to that kid and those caregivers, and they had never seen the social worker. And bad things were happening to that kid. But those are the types of things that we need that independent confirmation about what's going on. It doesn't mean that you don't have to ask, you have to ask providers for the same information that you're already getting, right? Like if you've got stuff like that already, but we do need you to verify that this is actually what's going on. Trust, but verify. And then if you don't have time to work your case, even if it's just for like a month, hey, I had some really bad life stuff going on, let your coordinator know so that we can make plans.
I have occasionally reading an ISSP stumbled on something that was going on with a kid in a case that I didn't know was happening. And it's usually something like, oh, they had to make another trip to the dentist. It wasn't anything major, but it's one of those things that, let me know that I wasn't being as thorough as I thought it was. And, I mean, the parents, the caregivers didn't tell me that the kid in this case was too young to tell me. So I didn't know. But, it just gave me another thing to go do. But, it's especially true for when you have parents that are in something like family recovery court. So they're in treatment, and the people that do that treatment are not going to call you up and say, oh yeah, this, an extreme case would be if somebody relapsed in treatment and you find out about it a lot later than you should have. So I try to stay in contact, establish a contact with the treatment givers and stuff like that. But in some of my earlier cases, I had some surprises like that. So I learned all the possible places you could find out stuff about what's going on with the kid, besides school and medical, and also going on with the parents. So
yeah,
it's one of those things.
Thanks for sharing, Tom. And again, if you don't have time to work your case, let us know so that we can develop a plan to kind of how we can get the work done in your absence or why you need to take a break. Don't just not do it. You have to understand, our coordinators are hearing this all the time. Most of them have been doing this for a long time. They've heard every story. It's okay. Use them. All right. Janet asks, what if you have a parent's attorney that tells the social worker you as a VGAL cannot be told anything about the parent, such as UA results, or if the parent is following through with their services? The social worker said she could not tell me. I asked for discovery and did not receive it until after court. So yeah, the parents' attorneys have that ability to kind of withhold. They don't want you talking to their client. That's totally legit. They can totally do that. What that means, what that means is that sometimes in your report, you're going to say, I reached out to the parent to confirm this, but I wasn't allowed access. And that's where we leave it. And especially if you don't have a release of information from that parent to kind of talk to these providers and things like that, it's going to be very limited what you can say. That's okay. The court's aware of that limitation. You just need to let them know. Parent won't sign a release, and they won't talk to me about any of the materials that are going on. I can't provide any additional information, Your Honor. H, volunteer for H, please.
I can do this one.
Thanks, Tom.
My microphone is a little flaky. A guardian ad litem shall not require any evaluations or tests of the parties except as authorized by statute or court order issued following notice and opportunity to be heard.
You can request an evaluation of a child when it's supported by fact, or parent or caregiver when it's supported by fact. The court gets to decide if the evaluation is warranted. You do not have the authority to require anyone to be evaluated, only the court. You can't even hint at it. Because what happens then, especially like if you're talking with a parent, if it's not something that's court ordered and you think, oh, have you thought about this or you thought about that, they will take you to court and say, Your Honor, this guardian ad litem they're doing your job for you. They're making all these recommendations. You cannot do that. You can only do that if it's the court says. You can only ask for anything if the court says it's okay. You do not have the authority to tell anybody anything. Even if in your professional career, you are an evaluator for that particular service that you think the kid could benefit or the parent could benefit from. You still have to ask the court for permission for that parent and authorization for that parent or child to be evaluated. I'll be honest with you. If the court knows that about you, that that's what you do for a living, and you're saying, I really think this kid needs to be evaluated, they're going to listen to you. But you just can't say to anyone, I think the kid has this. I think they should be evaluated for that. You have to get the permission of the court before that goes through. Questions about requesting evaluations? Anyone?
I just say thank goodness for my supervisor because he'll have to answer those questions for me.
Right. Excellent. All right, volunteer for I.
I'll go ahead and read it.
Thanks, Cynthia.
A guardian ad litem shall file a written report with the court and the parties as required by law or court order, or in any event, not later than 10 days prior to a hearing for which a report is required. The report shall be accompanied by a written list of documents considered or called to the attention of the guardian ad litem and persons interviewed during the course of the investigation.
So hopefully most of you by now have had to file a report to the court, right?
Mm-hmm.
And you'll notice in those reports to the court, there's a spot in there that says, what documents have you reviewed? Who have you talked to? So that the court knows where you are getting your information from. And hopefully you all turning in your reports at least 10 days ahead of time, if not 15, because most of the programs like a week or so to kind of review it before they actually file it. The court deadline is 10 days. Your deadline might be 15, so that the program has a chance to review it before you actually file the documentation. And the reason we have that 10-day requirement is because people can look at that. So mom's attorney or dad's attorney or mom or dad or the social worker can look at that and be like, I disagree with what that person said here. They have 5 days to file their disagreement with the court. And then you may get that disagreement and be like, that person doesn't know what they're talking about. Here's my rebuttal to that disagreement. You have 3 days to file that. So it goes 10, 5, 3. And the court likes to see all that back and forth ahead of time so that they know what they're stepping into when it comes time to that hearing. And a lot of times you'll hear courts say, I've read this, I've read that, I saw this, I saw that. They're letting you all know what they've read and reviewed before they actually sit down in hearing, just like you do. And they like to get that back and forth so that they can, when it comes to, so that we can effectively use court time, right? I've already read the back and forth. Where are we now? Parties have an opportunity to object to your recommendation. The court does not have to follow your recommendations. That's true too. Just because you recommend it doesn't mean the court has to follow it. It's the court's decision, not yours. And then sometimes information will be gathered that should be shared with the parties without waiting for the next hearing. Information that is pertinent to the child's safety or well-being, the parent's participation in progress and services, or impropriety by another party in the case should be reported quickly to your coordinator to determine the best way to get that information to the rest of the parties in the case. Sometimes we'll file a motion, you know, to get that thing done. We can use the court process to kind of let the court know what's going on and why we're changing course of action. But you need to let your coordinator know that so that we can determine how do we get that information to the court. The other time that this comes in too is that you'll file your report within 15 days. And there's a lot of stuff that can happen in 15 days in a dependency, especially as we're getting ready to go to court. Things happen magically that we've been waiting for it to happen all along so that the department doesn't look bad when they come to court. So there may be circumstances where you either, so if you've got additional information that needs to go to in front of the court before the next hearing, ask your program the best way to get that to them. Sometimes they'll have you filed an amended report where you add, you know, an actually written thing, or others, they'll just say, let's talk, when the court asks you if the CASA has any, or the child advocate has anything else to add, that's where you add that. Here's the thing I'm also going to ask, if that's the situation where you have to talk in court, Write that out first. Don't just think you can go there and write out what you're going to say. I guarantee you the court will appreciate that way more than you stumbling and stammering through what you need to get through. It is very intimidating to talk in court, right? Write down what you're going to say, practice it, and it is completely okay for you to read off of your piece of paper. Questions? Okay. Jay, may I have a volunteer for Jay?
I'll do it.
Thanks, Dan.
The guardian ad litem shall comply with the court's instructions as set out in the order appointing a guardian ad litem, and shall not provide or require services beyond the scope of the court's instruction unless by motion and on adequate notice to the parties. A guardian ad litem obtains additional instruction, clarification, or expansion of the scope of such appointment.
There are only two people in this work who can tell you what to do. Your coordinator and the judge. That's it. Not the social worker, not the relative, like only your coordinator and the judge get to tell you what to do. So anytime you're asked to do something beyond the scope of your duties, you can say no, and you should say no. So for example, a social worker asks you to pass on information to the foster parents about the parent's medical situation. No, that violates at least 3 or 4 different GAL, if not statute already. You're not allowed to share that information. That is beyond the scope of your duties. A visitation supervisor asks you to watch the family for a quick second. No. Beyond the scope of your duties. A parent calls you on Saturday for advice on whether to take the child to visits with the other parent. No. You cannot say that's okay or that's not okay. You can give suggestions about how to answer that, but you cannot give permission. The relatives beg or casually ask you for information about the child's situation. No. What's a good response to pretty much all of these bullets? Or at least the last 2. Anyone?
It seems like most of them, you could refer them to the social worker.
That's exactly it. I can't give you that information, but have you talked to the social worker? Yep. Tell them to contact the social worker.
And I would say more often than you would think, I get the reply, well, the social worker is very hard to get hold of or doesn't respond or blah, blah, blah. I'm not holding it against the social workers, but from a lot of people's point of view, the social worker is sitting by the phone waiting for them to call or, reading their every email or text or whatever, but not often true.
What you can tell them to do is maybe CC you on the message. But yeah, I know they'll always say, well, I already tried that. And you just have to say, I'm sorry, I can't, I'm not authorized to do that, or I can't tell you the answer to that. Kay, I want to volunteer for Kay.
I can read that.
Thank you, Rachel.
Informing people about your role. A guardian ad litem shall identify him or herself as a guardian ad litem when contacting individuals in the course of a particular case and inform individuals contacted in a particular case about the role of a guardian ad litem in the case at the earliest practical time. A guardian ad litem shall advise information sources that the documents and information obtained may become part of a court proceedings.
Thank you. We talk about this too, but this is just you. Hopefully by now you kind of got the hang of this. When you're first meeting with somebody, just explain who you are and why you're there. Hi, my name's blah, blah, blah. And I'm here to represent the child. You know, I'm the child's guardian ad litem, and I'm here to represent that child's best interests. I'm not an attorney. I'm here to gather information for the court so that the court has all the information they need to make good decisions on behalf of these kids and these families that they're working with. You also need to let folks know too that what they tell you can be shared with other parties in the court as part of that decision-making process. Most importantly, for you all, that includes kids. You do not have a confidential relationship with your children that you're representing. What they tell you, and you need to let them know this too, what they tell you, you may need to let other adults know so that we can keep you safe. But you cannot keep secrets. That's the best way I've heard other folks say, explaining confidentiality to especially younger children. I can't keep secrets, so I may have to let other people know what you tell me. Even when they say, can I tell you a secret? You have to let them know and make sure that they know what you tell me, I may have to share with other people. And then they tell you something silly like, I want to be a princess for Halloween. After you're sweating because you're like, oh my gosh, they're going to tell me something really horrible that is happening to them in foster care. And it's just something really silly. But especially for your older kids too, making sure that everybody knows that you do not have a confidential relationship. Questions or comments about that, or anyone? Cindy asks, is it okay to ask all parties for a shared planning meeting to discuss child's feelings of fear of going to visits, or should I just ask the social worker to schedule this? If it's getting to the point where you're thinking that these visits are causing more, like there's legit fear, not just inconvenience, but fear. Yeah, I think it's okay to talk to the social worker or ask for a shared planning meeting. Maybe even talk to the kid's therapist too, and just say, they're having these severe reaction to these visits. What should we do? But Cindy, that would be something that you'd want to talk to your coordinator too about. Before you start talking to the other parties. I should put that out there. All right, L, may I have a volunteer for L?
I can do that. This is Mary.
Thanks, Mary.
The guardian ad litem shall be given notice of all hearings and proceedings. A guardian ad litem shall appear at any hearing for which the duties of the guardian ad litem or any issues substantially within a guardian ad litem's duties and scope of appointment are to be addressed.
Show up to the court hearings. I can't, even, especially nowadays, you can show up via Zoom. Like you don't even have to pay for parking anymore. It's so easy to show up for these court hearings. Even though I know you may be thinking, oh my gosh, I don't have anything to say. It's all in my report. I never say anything at these hearings anyway. There are other people that are keeping track of whether or not you show up. In particular, there was a study done a couple of years ago by the University of Washington where they were measuring whether or not you guys were showing up. That's all. And they were saying that you didn't, and that's why we shouldn't have volunteers doing this work, because you don't show up. Even though you've submitted, and we tried to tell those people, well, they've submitted their reports. They literally don't have anything else to add. There's no reason. That didn't matter. It doesn't look good. You guys have been entrusted with great responsibility, and you're parties to the case. You need to show up, even if you don't say anything. It lets the court know that you're active on this case as well. If you go ahead, Tom, sorry.
I was just going to say, I have had a few cases that are involved with Family Recovery Court, formerly known as Drug Court. I show up for those hearings too, and they're a lot more frequent than the dependency hearings. But it depending on the judge and the case. I mean, I'm just sitting in the audience, hopefully in the front pew, but in the audience. And the judge in some cases have asked me if I have anything to say, because I have close contact with the situation, and even in that case, what I have to say counts. Plus, if you've ever been to a Family Recovery Court graduation, it's a great thing on your case to be there for.
Thanks, Tom. If you can't show up, let your coordinator know. That way they can at least be on the listen and tell them what you're listening for, or what your expectations are of the proceeding. And they can fill in for you if need be. But you should always try to prioritize that. Even if you're on vacation, all you snowbirds, it's so easy to show up via Zoom now. Show up. M. Volunteer, please.
Well,
I can do that. GAL2M ex parte. How do you say that?
You got it. Ex parte.
No. Communication. A guardian ad litem shall not have an ex parte communications concerning the case with the judge or judges and commissioner or commissioners involved in the matter, except as permitted by court rule or by statute.
Don't talk to the judge. These are really simple. If you see them out in the hallway, don't say anything to them, even if they come up to you. We have told them all, do not be offended, your honors, if our advocates do not speak to you, because we've told them not to. You can say hello, but that's it. Even if they ask you, you're not allowed. It's okay to say, or just walk away, or just not be like, hey, your honor, I can't talk to the case. I don't feel comfortable talking to you about the case. The other thing you cannot do is directly email a judge, right? You'll be listening in on the hearing or whatever, and you'll be like, oh, that's not true. I'm just going to email, or I don't like the decision that judge made. If only they had this piece of information, they would have made a different decision. I'm just going to email the judge really quick. Oh my gosh, don't do that. You are not allowed to talk to a judge, unless the only way you can talk to a judge is when you're on the record, or you're filing that piece of written information that the judge needs to see through the court. You are not allowed to directly contact a judge ever. Even if you see them at a gas station, a cocktail party, whatever, get out of there. Or at least don't talk to them. N, this is a long one. May I have a volunteer for N?
I'll do this one.
Thank you, Cindy.
Confidentiality. Maintain privacy of parties. As an officer of the court, a guardian ad litem shall make no disclosures about the case or the investigation except in reports to the court or as necessary to perform the duties of a guardian ad litem. A guardian ad litem shall maintain the confidential nature of identifiers or addresses where there are allegations of domestic violence or risk to a party's or child safety. The guardian ad litem may recommend that the court seal the report or a portion of the report of the guardian ad litem to preserve the privacy, confidentiality, or safety of the parties or the person for whom the guardian ad litem was appointed. The court may, upon application and under such conditions as may be necessary to protect the witnesses from potential harm, order disclosure or discovery that addresses the need to challenge the truth of the information received from the confidential source.
Thank you. Everything that you are dealing with is confidential. You're required to maintain the privacy of the person with whom you're working. We've talked about this, but you have access to an amazing and an alarming amount of information when it comes to these kids and these parents and these families. Don't share that. You gather information, you don't give it away. If you breach confidentiality, even a little or unknowingly, we need to address it. There's no such thing as I broke a little bit of confidentiality. It's just like you can't be a little bit pregnant. You either are or you're not. You either violated or you didn't. But when you do so, you need to let us know so that we know how to handle it and we can help you navigate how to handle that. If it's super bad, we may dismiss you from the case. And if it's really, really bad, we may dismiss you from the program. But even when you accidentally mess up, or you're driving away from the visit and you're like, oh my God, I shouldn't have said that. Call your program up and let them know. You'd be surprised how quickly information passes from caregivers to social workers to parents' attorneys. If only we could get referrals to act that fast. Oh, questions about confidentiality. I feel like we drill this into you guys, so hopefully you don't have confidentiality questions. Okay. Oh, volunteer, please.
I can read it, Ryan.
Thanks, Brett.
Perform duties timely. A guardian ad litem shall perform responsibilities in a prompt and timely manner, and if necessary, request timely court reviews and judicial intervention in writing with notice to parties or affected agencies.
Don't let kids linger in the system longer than they need to. Don't be the cause of any delays, right? Like, do your work. Make sure that you're not being the one that you're not the one holding the kid up. If the kid can go home because it's safe, don't wait for the next court hearing that's a month away. Do it. Tell your program, kid's ready to go home. There's no reason why we shouldn't be doing this. We'll file that motion to get that kid a month home sooner. I know that doesn't seem like it's that long to you, but for a kid, that's a long time. The other thing, if you have information or a concern that needs attention, don't wait for the next court hearing. Talk to your coordinator about it so that we can help you map out what the appropriate course of action is. Maybe file a motion, and maybe just sending an email to the social worker. Maybe just, hey, could we have a shared planning meeting? Kids are really upset by these visits. What should we do? Also, this applies to you as well too, and you guys should all know this by now. Do not think that you can wait until the last week before your hearing and call everybody and get the information that you need to include in your report. It never works that way, ever. That'll be the week that the foster parents decide to take the kid on vacation for 2 weeks, out of cell phone coverage. I just do these, set up a routine and follow that routine, right? I talk to the kids this week. I talk to the parents this week. You know what I mean? Like, give yourself a rhythm and a flow. And if you're having trouble staying on top of your case or you're just overwhelmed, talk to your coordinator. We can help you set up a game plan. But don't tell your coordinator, I don't know what to do. The coordinator, you should be going to your coordinator and saying, I'm having a hard time keeping track of all this stuff. Because if you go to them and say, I don't know what to do, they're going to yell at me as your trainer and say, Ryan, this training isn't working. And that will make me very upset. All right. P. We have a volunteer for P.
I'll take this one, I guess. A guardian ad litem shall maintain documentation to substantiate recommendations and conclusions and shall keep records of action taken by the guardian ad litem, except as prohibited or protected by law and consistent with Rule 2N. This information shall be made available for review on a written request of a party or the court on request. Costs may be imposed for such requests.
Two things in this one. You need to keep track. You need to take notes. I know, and some people will say, oh, I don't need to. I'll remember that. You will not remember this. The conversation that you had 3 years ago when you're on the stand for a termination trial. One of the best things that I've heard that folks do is they just have a notebook that they just carry with them all the time. And that's where they keep all their case related stuff. That way, if they're ever taking a phone call or whatever, they can jot down what it is, what they talked about. They have that information right there. Write it down, date it, time, and what date it was, what time it was, and who you talked to. And then organize your notes in a way that works well for you to easily access and recall them. I get folks every once in a while will be like, can you do a training on how to organize your notes? No. You guys are adults. Like, if you haven't figured out how to organize information, I don't know that there's a training that I can give you that will help you with that. Do what works for you. Some people just have a notebook and they just keep track of it that way. And then later on, they use sticky notes to flag it. Just, there's all different kinds of ways to do that. Ask your program coordinator. They probably have better ideas than I do. Betty, I saw, oh wait, there's a little bit more. Keep in mind that the parties and court can request to review your notes at any time. Your notes are discoverable. We've talked about that. Any stuff that you're using, anything that you write down is discoverable. Record your information accurately, repeat back to confirm and ask for clarification. For those of you that struggle taking notes, I have found this to be a really helpful skill to build, as that as you're taking notes, you know, when the parent or whomever you're talking to takes a breath and say, repeat back and read what you wrote down. I heard you say, boom, boom, boom. And they'll either say, yep, that's right, or no, let me rephrase that. That's fine. But asking for those using your notes as a tool for you as a process of your information gathering or interviewing them is another way to kind of help reinforce that good note-taking skill. Your notes need to be professional and fact-based, behavioral-based. Keep your opinions, frustration, and judgments out of them. And finally, you are not allowed to record conversations. Period. You cannot use electronic means to record conversations. Questions about that one?
I just want to interject that a lot of my give and take now with caregivers and the parents and so forth are electronic, usually text messaging or emails. I have means, because of what I used to do, to capture all that, but a lot of people don't. So you may have to get with your coordinator to find out how much of that. It's all discoverable if you've got a bunch of text messages with the parents on your phone, short of turning your phone over to the court when it goes to trial. If that ever happens to you, you know, you might see if maybe the county you're with or whatever has a way of capturing that information.
Yeah, Tom, one of the things that some of the recommendations that our folks have made in the past is using like Google Voice and setting that up as your text number, because then that way you can see that you can actually pull that up on your computer and it saves all those text messages that way. So that way, and you can give them out, give that. The problem is you got to remember to check that, but that's one way. At the very least, what we'll have folks do is they'll just do screenshots and go through all of your texts and take pictures. And then we send that off. Betty, did you have a question?
I did. I'll read the next one, but I do have a question.
Okay.
Can we, in taking our notes, I'm an information scientist, so you're right. You can't teach people to take notes. They have to take their own. But is it permissible to put certain words in quotes that have been shared with you to use later in your reports?
I think that's completely acceptable. Yeah.
Thank you.
There's no problem with that. Anyone else? Okay. You're on, Betty.
All right. Keep record of time and expenses. A guardian ad litem shall keep accurate records at the time of the time spent, services rendered, expenses incurred in each case, file an itemized statement and accounting with the court, and provide a copy to each party or other entity responsible for payment. The court shall make provisions for fees and expenses pursuant to statute in the order appointing guardian ad litem or in any subsequent order.
So this is one of those areas where we significantly differ from our Title 26 counterparts. They get paid, you don't. But we do need you to keep track of how much time you're spending on these cases. There's a variety of reasons for that. One, it looks really good when we're talking to legislators or county commissioners about how much time that you're giving, time that would otherwise have to be paid for. So that's a benefit, right? The other thing is that sometimes we need those hours because we include you, or the county includes you as in part of their insurance pool. And so in order for you to claim activity, right, and be covered under their liability insurance, they need you to report your hours. Here's the other thing. It does not have to be perfect. Do not let perfect be the enemy of good enough. It's fine. Oh, I work 10 hours. Give us something. Same thing goes with mileage, even though we don't, some of the programs reimburse you. They all have different policies about how to reimburse you for mileage, but sometimes we can reimburse you. So don't be afraid to keep track of that as well. That's it. Oh, did you want me to go back? There. That's it. It's so convenient for naming that these go all the way through Q. I thought I was so clever when I said minding your P's and Q's and all the other letters of the alphabet. So anyway. Any questions before I give you some scenarios? Anyone? All right, so I'm going to break you up into small groups. So these are new and improved, and they're kind of difficult. So you're getting the harder GALR questions. Perfect. Okay. In the chat, I'm going to put a Word document that has GALR scenarios in it. Your group number is the one that I want you to address. Right? So group 1, you'll do question 1. Group 2, you'll do question 2, etc. And I'm going to put those in the chat. And again, I apologize. I apologize for any typos. I did these kind of late yesterday evening. So, and I was just rereading. I only got to like the second one. I was like, oh my gosh, there's a bunch of typos in this. Don't hold that against me. Just politely correct me. Here we go. So let me drop those into the chat for you. As soon as I find them. Here we go. So I'm going to give you about 10 minutes in your 15 minutes in your small group. So read it out. Make sure that you understand what the scenario is. Again, group 1 does question 1, group 2 does question 2, et cetera, and so forth and so forth. And then we'll come back and have a discussion. So you need to think about which of the GALRs apply to this and what you're going to do. Okay. What questions do you have about this activity?
I have no idea how we'll break into groups.
I'm going to do that for you.
Thank you.
Yep. Anyone else? All right. See you back here in about 10 minutes. And if you can feel free to go on to another one. If you finish that one up and it's super easy in your group, pick another one and go through. Okay. Hey, everybody, welcome back. Did any group need more time?
We would have needed more time if we had the questions, but we didn't get it.
Oh, I'm sorry.
I saw it in the chat box. I tried to open it. It just said save. It only gave that option. And then when I clicked out to go back and try it again, the chat was gone.
I'm so sorry about that.
That's right. So we just chatted about our work in this field.
Okay, fair enough.
That was group 8.
Yep. All right. Group 1. Would you read your scenario and then kind of what the discussion that you guys had?
Sure, I'll go ahead and read it. You have a bunch of baby clothes that you're trying to get rid of at a community yard sale event. A family comes up to you and offers to buy the whole lot for a significantly discounted rate. They tell you they've just become a placement for their nephew and are in desperate need of baby clothes. They have none and they're on a limited income. You happily give them to them at a discount. The next day you receive an email from the social worker on your case informing you that your child has a new relative placement. And as coincidence would have it, it's the family that you sold all your baby clothes to on the cheap. So our group decided this was the whole conflict of interest. Nothing was really wrong. Nothing was done wrong. However, what we would do is immediately contact our supervisor and the social worker and let them know that you had sold these clothes to this family.
Yeah, this is a situation where this may not be a conflict of interest and you didn't know, right? Like unintentionally. And this would be a situation where we'd be like, hey guys, guess what happened? To all the parties on the case, is everyone okay with this? And I'm sure everyone would say, unless you have a really persnickety parents attorney, and they're out there, I know. But, this should be okay. So, but again, it is one of those things that you don't ever assume, I think it's okay, therefore it is okay. Use the program to your advantage.
Would you rely on the social worker to notify the parent's attorney, or would you do that?
I would always rely, Tony, how long have you been doing this work?
12 years.
Yeah, never rely on the social worker to do anything.
I wasn't talking about me. I was asking if you would do it.
No. I would tell my program coordinator, let them email all the parties and let them know what happened. Yeah. Thank you. Group 2.
We discussed this, although I don't have the question in front of me or the the statement in front of me.
Oh, I'll
So-
read it then. Okay.
Okay.
When visiting a relative in a sketchy part of town, you ask your coordinator to go with you. As you are both introducing yourselves, the relative asks if either of you is an attorney. Your coordinator says yes and tells the relative when and where she graduated from law school.
We just discussed that wouldn't be an appropriate thing to do. That at that point, we would just, state who we are and what our roles are as a coordinator and a guardian ad litem.
So, but how would you handle the situation if your coordinator said, yeah, I'm an attorney?
Oh, if they said that, we didn't really discuss how we would handle that situation. We just discussed why it wouldn't be appropriate to do that.
What are your thoughts?
Yeah, my thoughts would be to just clarify that, every party has their own representation. And that her role, the coordinator's role, wouldn't be to give any advice as counsel.
Yeah. I mean, and so that it's super simple, right? You just say, you may have to clean up and say, but we're not attorneys, but she's not an attorney appointed to this child.
Yes, we wear a different hat at this point.
Yeah.
Yes.
So that's great that she's got that, but she's not representing the child as an attorney in this situation.
Yes.
Just be really clear. Because yes, sometimes even coordinators make mistakes. So. All right, group 3. Betty, Debbie, or Tom? What'd you guys come up with?
Would you read our scenario for us again,
I
please?
thought that might be the case. It's the 4th time we've attempted to reunify the child with his parents. And you know it's going to be yet another failed attempt because dad still hasn't completed his alcohol treatment yet. The child always goes back to the same foster parents that the child has been in since birth, and they are desperate to adopt this child. The child loves both the father and parents, and the child loves both the foster parents and dad equally.
We talked about what information we needed to get and to kind of pull it together in terms of how many times the child has moved residence from the foster placement to dad and back, and that should be public knowledge between the foster parents and dad. And we would also do some outside investigation about how far along is dad and how successful is he being in creating a situation where he may soon or not soon complete drug and alcohol treatment. And then we would probably have a large discussion about where do we go from here.
It's that piece about not picking an outcome ahead of time, right, Betty?
Correct.
That's that JLR where this comes into conflict with, because it could be the 4th time is the charm.
Yeah, I don't know if Debbie and Tom want to chime in at all, but we had a good discussion about it.
Yeah, I think part of it is the confidentiality. You have to be careful about what you share back and forth between the foster parents and the dad. And the kid may tell you some stuff that you've got that position if I can't keep a secret, so you have to write all that down, whatever the kid tells you about time with dad, time with foster parents, stuff like that. But I think you have to be careful with the confidentiality. I'm not sure why my video dropped out, but anyway, so that there's that, and you can't really take a position without knowing everything that's going on. And at least in our court report formats, there's plenty of room to put in there the history of the placements and why, and any recommendations you have about the current placement or whatever, and also about the dad. So, but the more facts you have, the better. And it's kind of like doing your taxes when you write those reports. If you don't have the facts, don't put them down. But
Exactly. Debbie, did you want to add anything too?
Oh, I think that's a great summation.
Okay, group 4.
I can read it. So the parent has routinely been showing up to visits high. The visitation center has just gotten training and authorization from DCYF to conduct rapid response UAs before visits in an effort to keep kids safe. As you show up to the visit to briefly observe the start, it seems pretty obvious to you that the parent is high and you're worried about the safety of the child while the parent is using. The visit supervisor asks you if they should go ahead and do a UA before they allow the visit to continue. And so we talked about this, and we basically said that we are not in a position to tell them to go ahead and do that UA. That we can say, you've just been trained on this, or you've just been given permission to do this, you must have protocol, maybe go to your supervisor or check with the department. But we're not in a position to ask them or to tell them to do the UA. The other thing is, we talked a little bit about how, yes, maybe we are concerned about the parent as we're walking up, but we wouldn't necessarily mention that to the visit supervisor. I mean, we're there to observe a visit, but not to necessarily share information to the visit supervisor. It is a supervised visit, at least that's our assumption, supervised or monitored. There's definitely a visit supervisor that's going to be there. And so I would just kind of let it play its course, but I would refer the visit supervisor back to whatever their protocol is, or to the social worker. That's what we agreed on. So,
okay. Others? I forgot how good some of these are. Okay, so first of all, there's no such thing as a rapid response UA. I was just making that up. But it's not up to the department to decide whether or not you're going to UA a parent. It's the court, right? So even though they've been trained by the department, you know, they're all ready to use this. Yay, we got this authorization, right? So you have to be careful about things like that too. It may be that agency's protocol to do whatever, but if the court says, if the court has not ordered UAs to happen before visits, nobody can authorize that, especially you. And you never should be in the position of saying, even if they ask for your opinion, never offer it. That's giving information. You are not allowed to give information you can only get. So as tempting as it may be, hell yes, we should, do that UA. No, that's not our role. Because
I hear you, Ryan. Ryan, I hear you. After observing that visit, and especially if it's a consistent issue, would it be appropriate in a court report to recommend that UAs be done prior to any visit? In other words, you're not making it at a time, you're asking the court to consider the evidence and then to decide whether or not in the child's best interest, especially if you see abusive behavior related to that person's inebriation or usage or whatever it might be.
Who's that hurting, Dan?
The child. So you're looking out for the child's best interest. You see the child being affected by their parents' addiction or practicing addiction at the time. So if you went back to court in the next hearing and said, but prior to any visits, the parent should be have some UA done.
Who is that hurting?
Well, as someone who's accustomed to alcoholics and their behavior, I say the children are getting hurt. if that's the case. I'm not sure by your question, I'm kind of getting the vibe that you don't think that a person who is, let's just say, drunk at the time is possibly harming the child's in some form or fashion.
I would need to see more information, but physically, no, I would not be concerned about them harming the child. And these kids need to see their parents. And I know we have this tendency, and you can come to the visitation recommendation training tomorrow, but visits are there for the kid as much as they are, if not more so for the child than they are for the parent. So when you're asking or actively asking for those visits to be cut off because of the parent's behavior, I would really encourage you to look at that from the kid's perspective.
And part of the reason I'm asking is because in my specific case, the child asked a number of times to not meet with one of the parents because of the conduct and behavior, which some of it was related to chemical addiction use. So
that's a different story. And that is something, that's a conversation that you have as maybe like a shared planning meeting or something like that, and say, hey, the kid's telling me this. And actually having and confronting the parent with that information and saying, they don't like it when you show up high. Is there a way you can show up not high or drunk? I don't care what you do after, but for the sake of your child, they're making this request.
yeah, and that's the course I think we took when
Good.
Ultimately the child got to decide whether or not they're going to see the parent on Zoom meetings, and then it evolved to a place where she just refused, period.
And if the kid is old enough to make those determinations for themselves, then we need to let them, help them kind of have that authority over their interactions with their parents.
Yeah, that's what we got to.
Yeah.
But part of it is due to the chemical addiction issue, I think.
Yeah, I hear you.
Yeah, keep in mind too, that that's not the first time that kid's seen their parents high or drunk. And, you know, that they, either that's the problem or it's something they can handle or it's not. But you got to make sure that you document all that too when those things happen. Every time they show up high, regardless of what the you know, there's all kinds of different levels of skill on the supervisors too, the visit supervisors. A lot of them can handle that situation, some of them cannot. I've had that happen. The parents show up for like a 2-hour visit, and 45 minutes into the visit, they're sound asleep, and the kid's in there playing by himself. Fortunately, you know, supervisor, it's a, you know, observed. So the supervisor is in there, you know, trying to change the situation. But, you know, it's any number of things can happen. But again, you know, it's like I say, it's not the first time the kid's seen their parents high.
Thanks, Tom.
You know, Ryan, we talked about that a little bit too when we were talking about this. And the one thing we did bring up was that visits can't, I mean, you can't keep parents from seeing their kids just because, you know, they have an addiction problem of some kind. And I think there is the safety piece, but it's also, you know, we walk in and this scenario says that we observe him, we know that he's high too. But I'm not always sure that I'm the best judge of whether he's high or not. I mean, it's one thing. I mean, there are some that are very obvious, but there could be another medical issue. And to jump to the conclusion that the parent is using without more information and then having that impact that relationship we're trying to build between the parent and the child, I'm just not super comfortable with that. And it was a trick that there is no rapid UA. I'm sorry. I thought that was real. So
at least not that I'm aware of. So okay. Again, these are all things that we're going to be talking about tomorrow. So in our safety planning training. But let's continue on. Who had, so group number 5. What'd you guys come up with? Leah, Randall, Sherry, Signe?
Well, I feel like I always talk, so I wasn't going to talk. Do I need to read it first?
Yeah.
It's a cold January morning. You've agreed to meet the child's caregiver at the local Starbucks. As she's about to pay for her cup of black coffee, she realizes she forgets her wallet. She turns to you and asks if you can cover her this time, and she'll pay you back next time she sees you. We felt like that was a pretty easy one that we know we can't do it. We shouldn't do it. Mainly our discussion was more about like that social like urge to want to do it, knowing that we shouldn't do it. We thought it would be under C, professional conduct, but it's also could be looked at as E, avoid conflicts of interest. So those were the two we thought it could fall underneath, based on, I gave the example of one of my peers was had a talking to due to purchasing an orange juice for a kiddo who was really thirsty during a 4-hour court hearing, right? So it is a serious situation that we understand we're not supposed to purchase things, but as social human beings, it's a really hard one that, you know, that we know we shouldn't do.
I know it, right? Like I set this one, I'm trying to make these a little bit more difficult. Like, oh, you know, it's just like, oh yeah, I'll get you back the next time. Don't worry about it. Like, don't, like, you just can't, and just say, I'm really sorry, I can't do that. Like, I just can't.
A lot of things we're kind of discussing too is like just setting yourself up for success. So I told them one thing I do if I'm meeting anyone, social worker, anyone in public, I always try to get there after, right? So like usually they're already sitting drinking their coffee or something. So then they're like, oh, I'll get it. Oh, no, I get my own. But I feel like once you're sitting down, it just feels like you're obligated to, I don't know, it just feels different than when I come in later. So I just always try to set myself up so I don't have to be put in that awkward situation, because I just think we're, you know, human and we naturally want to do things like that.
So there's a reason that you've justified showing up late to every one of your meetings, Leah.
Always. No, always. I really do. I literally do it. Or I'm like, hey, let's go to the mall and let's walk around the mall. Like I've just put myself in situations that I don't have to, because I am just that person who, I'll pay for everyone's drink. Like that's just me naturally. So I'm just like, set yourself up for success. So
thank you, Leah. All right. How about group number 6?
Hey, Ryan.
Go ahead, Brett.
I'm not sure if anybody else wants to take it, but our scenario was you're at the end of your case at the last review hearing where the adoption is to be finalized. However, right before the judge is going to sign the final order, she asks everyone if we could wait to finalize everything on the court's celebration of National Adoption Day, which is about 3 weeks away. The other parties agree. The judge is now looking at you. And so we had a little conversation, and in general, you know, everybody else agrees that it's okay. So I guess it would be okay. I did personally feel that, you know, putting it off for another 3 weeks affects everybody, you know, involved in the case, parents, the kid, the adopted parents. So, you know, if everybody's present, all the information's been presented, might suggest to the judge that, you know, maybe we push forward and finalize it today, just because everyone's present, we have all the information in front of us. But also maybe just ask, you know, the other parties, you know, why we would want to postpone it. Is it just for a celebration on National Adoption Day or what? And so, you know, you leave it up to the judge, I guess, to make the decision.
Yeah, this is that whole kids shouldn't linger in the system issue, right? We need to get them out. I'm sorry, but I have heard too many, like, life happens in dependency. Like, and heaven forbid, like, we get that kid, you know, squared away and something bad happens in between those 3 weeks. It does, like, weird things happen that cause cases to stay open another 6 months or another year. If you get to the finish line Don't stop right before you get there. And look around and like, no, like get it done. And you can lean on the GALRs and say, I don't want to be the cause of any delays to seeing this kid reach permanence. We're here. So, and Brett, I know it's hard to be the only person telling the judge no. But if you can articulate, so that's why that's kind of the theme of this conference too, like show your work. If you can articulate why it's important that we go ahead and finalize this adoption today and still have them participate, here's why. It's a rule.
Under that.
Good luck. Let me know how that goes for you. Oh. All right, group 7.
Hi, Ryan.
Hi, Bonnie.
Hey, we had 7, and 7 is dad has finally shown up at a 30-day shelter care hearing after you've been trying for weeks to schedule a time to talk with him. Dad's willing. It's just that his work schedule is very busy and doesn't align with yours at all. You have several things you need to ask him about, including if there's any Native American ancestry in his family and what his relationship is like with his kid. Mom's also present for the hearing, but you've been talking with her all along. We didn't have time to really discuss it. It was just 2 of us because I was trying to get the GLRs out to, I apologize, I forget the name of the person. It was
Me, Janet Bellis.
Janet, yeah, trying to get the GLRs out to her, and so we really got booted out before we really had a chance to really get into a discussion. But I was thinking that it would come under B, maintaining independence, where guardian ad litem shall maintain independence, objectivity, and the appearance of fairness, which is what I want to highlight, the appearance of fairness in dealing with the parties and professionals, both in and out of the courtroom. And so I'm thinking the concern would be that we were talking with father, since he was present in court, and mom is also there, but we're not talking with her, and she may be concerned about what it is we're talking about. And so I had 2 ideas. I have 2 ideas. One would be, and I don't know how the state court dependency hearings go, but I'm familiar with tribal court and with other states. But my thought was either raise the issue at the hearing that I had not been able to speak with dad. He is present, and it would be appropriate for me to maybe after the hearing have a conversation with dad while he's at the courthouse, so that everybody knows what the plan is, and they can object if they want to, or scheduling with the attorneys and the caseworker, maybe after the hearing, if I can round everybody up and say, dad's here, it works for both of us, so that everybody knows what's happening and they're not wondering and creating their own stories.
Bonnie, I really like that suggestion. Like, I kind of throw these up just, I didn't know what the answers was going to be, but I like that idea of letting the court, like at the hearing, saying, hey, is it okay with everybody here? I've been trying to meet with dad and I haven't had a chance. I've been meeting with mom, but I haven't had a chance to meet with dad. Is it okay if I talk to him after the hearing? And like putting that all out there in the open, on the up and up. I think that's a great compromise and a great solution to that situation. Because what you don't want to do, like you were saying too, you want to avoid that, like, I'm going to go talk to dad after the hearing, or I'm going to make a beeline for dad, because that's going to make mom think, what she got, like, she's been talking to me, like, are they conspiring against me? Like, I'm just, they make up their own, people make up their own stories about why you need to talk to them. And it could be something completely, like, you're like, what? Like when you finally talk about it, you're like, what are you talking about? I just need to talk to dad. I haven't been talking to him. I didn't, like, because they make up a story like, I said something in court and that's why you're doing that. And now you don't think I deserve my kids. You just never know. And so you want to make sure that you don't even have that appearance of favoring one party or the other. So putting that out there in the open like that, that's a great suggestion, Bonnie. Thank you.
Thank you.
All right. And my understanding is that the last group didn't have one. Oh, but we'll process this one as a group. You're talking to both the mom and her sister on your case. The sister is serving as the caregiver and as the placement for the child, as well as mom. She mentions to you that she's glad that she's finally going to get to tell the court about all the annoying stuff that the social worker on the case is doing later this week. It's been hard at court. It's been hard for her to get the time off to do so, but she's managed to convince one of her coworkers that to swap with her so that she can attend the hearing. And that means that the aunt is going to have to give up a week of the holidays in order for that swap to happen, but she really wants to be at court later this week. The hook is, you know that court case has already been continued. What do you do?
I don't know, Ryan. I think the only thing you can do is just say, you know, it's really important that you check with the social worker before the next court appearance to make sure that everything is going smoothly. I suggest you give them a call as soon as possible.
Yeah.
I mean, it's really hard. This to me, and I've been doing this a while too, this inability to give caregivers court date information is, to me, one of the most, all of these things are hard, but that's one of the most difficult things to actually not do. Does that make sense?
I hear you. Yeah, no,
Yeah.
it's, and Morgan and I have gone round and round on this very issue about whether or not it's okay to let the caregivers know when the next court hearing date is. And she wins. So.
Yeah, no, I know she does. I just don't like it. So.
I don't either. But those are the rules, right? Like, we have to follow the rules. So you can't tell them, oh no, that's been switched. But I would be like, you really need to talk to the social worker. Like, really need to talk to the social worker about when that next court date is.
I would
Ryan,
also
what's the policy for not just giving the factual information about the court date?
It's confidential, Dan. They're not parties. And you can't give non-parties information about the case.
I think of court dockets and whether they have, you know, that information public, and you could just show up. I don't know. I don't know if it's public.
It's not public.
Our court hearings are public in Whatcom County, Ryan.
The court hearings are, but not the actual calendar.
The dates and everything is public knowledge.
So they just have to keep showing up.
Everyone tells everyone, no, everyone up here, the caregivers, everyone. And I don't like to be the person that monkey wrenches with things, but the courtrooms for dependencies are completely open. Caregivers and everyone are allowed to come in and know about it ahead of time and afterwards, and dates are discussed in front of everyone and all of that.
It's fine. It's just that so according to the GALRs, you can't be the one that says that. You can discuss it. I know. Thank you, Cynthia.
Just like I was trying to hold back, but
I hear you.
Well, Ryan, I'm be the person who goes against everything, but the legal parties are the kids. So I tell my 6-year-old to leave the date, and the caregivers sometimes just, oh, I didn't see you there.
There you go. Brilliant, Leah.
No, but I do like make sure, especially my the ones that are wants to know, like I tell them when we have our conversations, the caregiver usually around, hey, you know, you are welcome to come to court to see the judge on this day, because they are like technically for our, and I am one who like look at our law, our rules, and be like, how can I bend them just a little bit? But no, I don't really bend them. But with this one, I think everybody has the same frustration. It's just that like when they've been emailing the caregiver every single day for weeks, or when they take off, it is really hard. And that's kind of when I have to use the kids, the legal party, because I'm just like, I don't know what else to do. And of course in 20 minutes. So I think that's when I use that last resort.
I hear you.
So I have also done emails from me to the social worker with a CC to the caregiver saying, social worker, can you please provide this individual with the court date?
Yep.
So I'm not really doing it, but
you're making sure that it happens.
I'm a really good ping person.
Yep.
I'll ping everybody that irritates me. And so that's what'll happen. They'll get a ping from me.
Thanks, Christy. Yes, Whipple.
Well, I think also case by case, if there's caregivers that are really reaching out for information, and in Whatcom County, the hearings are public. So if they want to know next dates for things, or they really need to have information, I'm not going to provide that information. That is not our role at all, but they can sit in that court hearing and hear
Absolutely.
the information.
Yeah, or tell them where they can get the information.
Exactly, because
right?
that's a part of our facilitation role, right? Yep. And back to the example of attaching them to an email. Yes, most definitely. That is a facilitating part of our role. It is facilitating that communication. So that's excellent.
Or you could tell them to call the clerk. Hey, call the clerk if you want to know when you know what I mean? Like as long as it's not you giving out the information, you're covered.
And also, if they're hassling a GAL or an advocate that much, there's more at play there than just getting that date.
That's why that paragraph was so long in the scenario, because I'm like, I got to make it anyway. Those are all our scenarios. What questions do you have remaining about the GALRs?
I just want to throw in a couple of things. A lot of programs like ours have programs or projects, groups that contribute things or have things that are available, like baby stuff, quilts for kids, all kinds of things. And I don't think there's any rule against you pointing somebody to one of those. In fact, some of that we actually are, like this one group makes quilts for the kids when they're babies. So as far as I know, we're allowed to transport that quilt from the program office. Of course, COVID kind of got in the way of that, to the kid. And, it's not a gift from you. It's a contribution from someone out in society. But there's all kinds of programs to get stuff into kids' hands. And there's no rule against you connecting those two. Just don't be the one that bought the thing or whatever.
Right. Or even I would even go so far as to drop it off too, to give that perception that you're the one giving them the brand new Nintendo Wii or all the Christmas presents that are under their tree, like avoiding that appearance that you're the one doing that. But yeah, connecting folks up to resources, whatever they may be. Feel free to do that with parents too, right? Like if there's a need, tell them they can fill that need. Just don't be the one that fills it for them.
Right.
Totally facilitation piece. Absolutely.
We just had a big estate sale where we gave away all kinds of stuff that families could need. But, we just tried to point it to places where we knew who was probably going to get it, like Pierce County Alliance, where all our drug rehab folks go. They can use all kinds of stuff for kids and houses and homes and, people. So, if you give it to PCA, somebody in the program is going to get it. But, it's just one of those things that you can't be the giver. Although I have heard from one of my now retired coordinators that said he used to make up mythical holiday contests that people could win a turkey dinner or whatever. And he would say, you know, somebody's going to come and deliver a turkey dinner. You won this contest. I entered you. I hope it's okay. Yeah. So no names, but he's long gone. So statute of limitations and all that.
There you go. Thanks, Tom. Anyone else?
I just want to say thank you. You've opened my eyes.
Good. That was the idea. Okay. Well, that will do it for today. Our next session is tomorrow, where we talk about safety planning and using that to inform visitation recommendations. So hopefully you can